Hello, everyone, and thank you for attending today's webinar, Make Confident Lending Decisions with Robust Liens and Judgments Insight. Before we begin, here are a few housekeeping items. At the bottom of your screen are several application widgets you can use. They are all resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. If you have any questions during the webcast, you can submit them through the Q&A widget. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, they will be answered later via email. Please know we do capture all questions. For the best viewing experience, we recommend using a wired internet connection and closing any programs or browser sessions running in the background that could cause issues. Webinars are bandwidth intensive, so closing any unnecessary browser tabs will help conserve your bandwidth. The webcast is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presenter. Some networks cause slides to advance more slowly than others, so logging off your VPN is recommended. If your slides are behind, pushing F5 on your keyboard will refresh the page. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. An on-demand version of the webcast will be available approximately 30 minutes after the event and can be accessed using the same audience link that was sent to you earlier. Today's speaker is Nick Larson. Nick is a director for LexisNexis Risk Solutions, overseeing the development of solutions for the real estate and mortgage industry that enable lenders to improve risk assessment, detect and prevent fraud, and expand their addressable market. His 30-year career has focused on the mortgage industry and gives him a unique perspective that differentiates LexisNexis Risk Solutions from other vendors in the marketplace. Nick is a regular contributor to national media. CCTV has interviewed Nick on anti-money laundering in the real estate industry. CNBC.com relied on his insights on consumer liens and judgments data being removed from consumer credit reports. National Mortgage News also frequently works with Nick. Welcome, Nick.
Good morning. Thank you. Thank you, everyone, for joining today's webinar. Appreciate you being here today. During this session, we'll provide an overview of changes to the credit report regarding public records, when they occurred and why. We'll review the resulting impacts to the real estate mortgage market as a result. And then finally, we'll recommend some next steps that you can take in order to provide the best consumer experience to help you in your efforts to meet your investor requirements as well as industry regulations. So let's get into a quick recap of the significant events that have happened since and what triggered the loss of the liens and judgments records on credit reports. So if we go back to March of 2015, that was the announcement that was in response to New York and 30 other states who had initiated a suit against the national credit reporting agencies, Equifax, Experian, and TransUnion, specifically to address data errors in consumer credit reports. And for those of you on this session, I'm sure you're familiar with instances and reports about the percentage of which consumer reports had one or more factual errors on the report. This is really what drove that suit. Now, as a result of that suit, the three national credit reporting agencies, or the NCRAs, and the state's attorney general agreed to what's called the NCAP settlement, or the National Consumer Assistance Plan. Now, NCAP is not a compliance requirement that's directed at lenders. Again, it was an action taken by the states specific to the NCRAs. Nor does that settlement or the action that they took indicate any concerns that there is no concerns with using liens or judgments for FCRA or Fair Credit Reporting Act purposes. And finally, it's worth noting that LexisNexis Risk Solutions was not a party to that settlement. Again, it was between the national credit reporting agencies and the state's attorney general. Now, going forward, in response to the NCAP settlement, in March of 2017, the NCRAs issued an announcement that stated that they will only begin reporting on public records at a certain point in the future that contains sufficient consumer personally identifiable information. And in fact, they were specific to say any record that they would report on would have to have 3 of these 4 following identifiable pieces of information, which are name, the address, their social security number, date of birth. And as folks who may be familiar with the kind of data that is available through the court records, Social Security tends to be a record that is not included in there. But their requirement is, of the 4 pieces of identifiable information, they will only report on records that have at least 3 of those. And the purpose of that is to ensure that they can properly link that record to the consumer, which is, again, a part of what the NCAP settlement was about. And they would also put in programs to ensure that the records that they were reporting on, they had revisited the source of that record on at least a 90-day period. Now, at that point that the NCRA has made that announcement, they also said that they expected that it would have an impact on the credit reports on or after July 17, which is when they said that they expected those changes would be applied. And that at that time, they anticipated that roughly 50% of liens and as much as 96% of the judgments would no longer meet that criteria on identifiable information. So they expected half of the liens and most of the judgments would begin to drop off the report around July of 2017. Now, in response to that, around June of last year of 2017, Fannie Mae issued their lender letter 2017-02, which was their guidance to their seller community, which the message on the lender letter was, trust the desktop underwriting decision, that in spite of this information dropping off of credit reports, the decisions that they were making out of DU would still be valid and sound, and that for the lender, no additional sources beyond the loan application or the Form 1003, the credit report or the title reports would be necessary, but if you continue to read the lender letter, they were very clear in stating that guide requirements would still apply. Freddie Mac issued a similar position to that of Fannie Mae. Freddie Mac obviously stated that the decisions coming out of Loan Product Advisor would still be sound and applicable, and that beyond, I think, really more manual underwriting, the guide section still applied, and that would be more applicable to the manual underwriting loans, or the manually underwritten loans, I should say. And then the FHA issued some guidance. I think it was more verbal. I don't remember seeing an actual announcement, but their position was very clear that there were no changes that would be made to Handbook 4000.1. In other words, their expectations that the lenders were still responsible for identifying any liens or judgments tied to any of the loans that they're processing. Finally, April of this year, April of 2018, Equifax, Experian, and TransUnion issued an announcement that stated that they were going to drop all liens and judgments from their credit reports in response to their market analysis from the past year. So at this point, let's go ahead and kick off one of the poll questions.
You bet. This is a question about you. The question is, has your loan origination and or approval process changed due to the loss of this data on credit reports? So you got 2 choices there, and all you have to do to weigh in is click your answer right there on the slide itself. Let's see, I want to make sure that we didn't click twice. There we go. Here it is. So right here's the slide where you'll click your answer right there on the slide itself, yes or no. Once you've decided that, then do hit the submit question, the submit button. Once again, the question is, has your loan origination and or approval process changed due to the loss of this data on credit reports? So one button says yes, the other button says no. Click that radio button right there on the slide itself. And after you've done that, hit submit. And then we'll go ahead and take a look at how our audience has weighed in.
And Mary, the purpose for asking this poll question is really to get a baseline from this audience in terms of understanding whether they've adopted any changes to their loan origination or approval process as a result of the content drop from the credit reports.
Okay, very good. Once again, the question, has your loan origination and or approval process changed due to the loss of this data on credit reports? answer right there on the slide itself, and then hit submit, and we'll go ahead and take a look right now at our audience's response to this. Here we go. Got 63% saying no. What do you think?
I think that's pretty consistent with the way most people interpreted the GSE or the Fannie Mae and Freddie Mac lender guidance, that ultimately no additional work would be required. The problem, as we'll get into a little bit later, is that there are some seller servicer or seller requirements that the GSEs, Fannie or Freddie, have that were stated in their communication that still apply. So we'll get into that. But this is what I expected. I did expect that most lenders would treat this as we'll continue the process as we have before the content change. So thank you, Mary.
You bet. Thank you. And go ahead and move on to your next slide.
Okay. So at this point, let's get into talking about a related topic that has garnered so much attention over the past year, and that's the impacts to the credit score. So there's been some publications, there's been news articles on the subject, and ultimately, when you look at the analysis that FICO and VantageScore did back in 2016 and 2017 on this topic, and has been validated by some more recent analysis, including that from the New York Federal Reserve and the BCFP, the formerly known as the Consumer Finance Protection Bureau, the expectation was that most consumers would only see a 10 to 20 point boost in their credit score if they had liens and judgments, and as a result of that data dropping off the credit reports. Now, they also acknowledged that there would be certain consumers who would certainly gain an even larger boost, but on average it was somewhere in that 10 to 20 point range. And the consumers who have liens and judgments, while they do span the entire credit spectrum from premium on down, most of the impacted population they saw had credit scores of around 620, which is again before the loss of the liens and judgments. So anticipate a slight increase from that, but the analysis that they did at that time, they expected that most of the consumers tended to have their credit score was already in that 620 or below range. Now, it should be noted that the boost that they would gain from the bureaus no longer capturing the lien and judgment data is significant enough that you could expect some consumers who wouldn't have otherwise been able to qualify for certain loan programs would now be able to do so as a result of that boost. And the BCFP, or the formerly known as the CFPB's analysis in their February 2018 quarterly consumer credit trends report showed that there was a high correlation of consumers who had liens and judgments who also had a 90-day plus delinquency show up on one of the trade lines on the credit report. So that spoke to where the GSEs, the investors, and the credit bureaus felt that overall there would not be an overall impact to credit scores because they would be able to see some sort of indicator of credit performance through the trade lines, even if they didn't see it on the liens and judgments. However, it should be noted that by the analysis that the BCFP did, that over 10% of consumers who had liens or judgments had no other signs of issues, no delinquencies, no other signs of financial stress. So they are a population of consumers where the credit reports would be blind to any derogatory information on their credit record. So regardless, the current consensus is that automated underwriting systems are still performing prudent credit decisioning. But the reality is, and again, through the BCFP's own analysis or statement, they expect that ultimately the market will need a couple years to really analyze actual loan applications and credit decisions to really understand the credit risk impact from the loss of this data, as well as really to understand consumer behavior in response to the loss of that data. But it's worth noting that the analysis that LexisNexis did back in February of 2017, we looked at mortgagors who had a lien or judgment and then looked at subsequent notice of defaults or foreclosures versus mortgagors, borrowers who have a mortgage but did not have any liens or judgments in their record. And what we saw was that there was a 5.5 times greater likelihood that those consumers, borrowers who had a lien or judgment on their record would end up in a significant delinquency, whether it was delinquency or foreclosure event. So what you can see from that analysis is there is a high correlation of that lien and judgment record to loan performance. That even though it from a credit scoring perspective, it may not have a significant impact and doesn't materially affect the manual underwriting, there is an aspect to it in terms of loan performance that has not been really understood until we go through that 2-year period. Now, at this point, let's get into what's beyond the credit scores, because much of the press, as I said earlier, was related to the scoring impacts from the loss of that data. But now let's spend some time looking at the impacts from that were of the data drop through NCAP that didn't generate that same amount of attention. So beyond the credit scores, we're talking about validating key loan application data. As lenders are well aware, they're ultimately responsible for ensuring the accuracy and the completeness of that loan application data, including whether the applicant has any active liens or judgments. As we've discussed earlier, if the applicant does, our internal study indicates that that information really matters. Meeting the investor requirements. So we've talked about how FHA has stated that the handbook 4000.1 still applies, no changes, and how the GSEs, Fannie and Freddie, have said that you can trust the decisions that come out of the application, but they also state that in certain conditions, or in most conditions, that the guide requirements still apply. And in fact, Fannie had cited a couple specific guide sections there. So while ensuring the application data accuracy is an investor guarantor requirement, knowing about any active liens or judgments impacts some of their other requirements. And we'll get into that in a couple minutes. And finally, compliance. So not adhering to investor guarantor requirements, while it may create repurchase risk, not complying with the state and federal requirements opens your company up to audits, and then obviously the resulting fines, adverse actions, and certainly the reputational risks that come of that. So one of the key pieces here that we want to focus on in terms of the key loan application data is, as you can see on the screen right now, one of the questions that happens on the universal loan application, or the Form 1003, is Section 8 declarations. The very first question there is where the applicant and the co-borrower state, did they have any outstanding judgments against them? So as we discussed earlier, lenders are responsible for validating all the data which is relevant to that loan application decision. It's also worth noting that the investors and guarantors hold the lenders as ultimately responsible for the accuracy of all the loan data that they use in considering investing in or guaranteeing that loan, right? So in this example here, if the data doesn't show up on a credit report, you see it on the Form 1003 or the loan application, what is your way of being able to validate the accuracy of that data? Now, if you are currently using a third-party report that identifies liens and judgments tied to consumers, or considering using one, it's important to recognize the importance of using reports or tools that are compliant with industry regulations or expectations. So for example, if any of you are using non-FCRA reports that contain liens or judgment information, the usage of these reports in whole or in part for a loan approval process creates a regulatory non-compliance risk for the lender. So remember, using liens and judgment information during the credit underwriting process requires compliance with the Fair Credit Reporting Act. Therefore, any of the inputs or data that are used to make a decision should be FCRA compliant as well. In other words, the decision that you make whether to kick off an FCRA process or not should be driven by FCRA regulated data, especially if the data from those reports are used to engage the applicant to supply supporting information, or more importantly, ultimately, to decide upon what loan or terms to offer that application. That applicant should be driven by FCRA data. For those of you who are using preliminary title commitments or waiting for the actual title report to come back, These products are predominantly focused on researching the clean chain of title of property ownership leading up to and including the pending sale. They do so with the intent of ensuring against any potential challenges to property ownership. Again, they're protecting that the new buyer and the lender who's issuing a loan against that property have the right to be able, they own that property. So as part of the process, the insurer will, among other things, research for any potential liens, judgments against the home, the seller, as well, and to a certain extent, the home buyer itself. They're looking to see if there's going to be any challenges around the ownership of the property or around any related proceeds. So specific to researching those potential records, the insurers are generally geographically limited in their search. In other words, where the property is located, and if it's different, where the home seller is located tends to be the predominant area of focus for their research. And while the insurer can certainly hedge for any risk of filings that are discovered outside of their search area or that did not pop up during their review, the question is, what is your hedge to the risk of repurchase from your investor or guarantor as a result of a challenge like this coming forward? I should also point out that depending upon where the title insurers obtain their data from, they also face the same challenges bureaus faced when they were pulling the court data in regards to those records having limited identifying information in order for them to be able to determine whether the records pertain to any of the parties on that transaction. And it's probably at this time worth noting that it's the courts and the state and local governments who define what data is required to be captured on the documents in order to be filed, but also what data is publicly disclosed. And they do so to marry the balance between being the source of public record for significant actions, but also protecting their consumers in their area. I'm not aware of any organized effort to change their current data requirements, so ultimately these records are going to contain the same amount of personally identifiable information that they've had at this point, barring any upcoming organizational change. And realize that for that to be effective, that has to be really on a national level. Finally, it's worth mentioning that the insurer's process of researching the available data and issuing their preliminary title commitment takes time. It's not an immediate response. And in today's origination environment, especially with the digital mortgage evolution, the expectation of a quicker closing time frame between application and settlement, waiting for that information to appear potentially creates issues for lenders related to pre-qualification and certainly risks to closing dates. So at this point, let's go ahead and proceed to another poll question.
Yep, that's great. We will now take a look at this question from our audience. How does your company research potential liens and judgments in response to applications? We just want to know a little bit more about you. Your first choice is we don't, per the GSE's 2017 guidance. The second choice is we rely on the preliminary title report. If that's your answer, just click it right there on the slide itself. And the third choice is we also obtain a third-party liens and judgments report. So this is another one. You can click right there on the slide, and then once you've chosen your answer, the one that applies to you, hit submit. And then we will have your answer as part of our report back to the question, how does your company research potential liens and judgments in response to applications? You don't have a one-size-fits-all, in other words, all of the above answer here, so you're going to make people choose, aren't you?
Yes, Mary. And it's similar to the last poll question, but ultimately, what is right now the Fannie and Freddie guidance is to rely on the loan application, the title report, and the credit report. So the question is, how are they dealing with liens and judgments in this new world that we're in with the credit reports?
Yeah. So once again, the question is, how does your company research potential liens and judgments in response to applications? And just about everybody has weighed in. They've all clicked their answer right there on the slide itself and then hit the submit button. So we will take a look at the response from our participants today. And there it is. Most people are obtaining a third-party lien and judgments report. What do you think?
That's actually a pleasant surprise. Here I expected the numbers to be closer to that 60-40 split that we saw on the initial one. It's about the same, but there are people who are relying on these third-party reports. And so that as we get into the next topic, I think that's you'll see that that's a good practice.
Mm-hmm.
So thank you, Mary. So let's move on. So, we talked about the attention to credit scores. We talked about the impacts beyond the credit score. So let's delve into those three that we talked about earlier and start with the investor guarantor requirements. So we talked earlier that FHA made no changes to their handbook. Fannie and Freddie both stated that their systems could still be relied upon regarding the loan approval, but ultimately lenders are responsible for compliance with their existing policies. So let's get into where the liens and judgments have special applicability to those investor requirements. So as you can see here, validating the loan application, we talked about data accuracy, and we also focused on that one specific question in the declarations. But again, this is worth repeating that all the data in that loan package, that the lender is responsible for ultimately validating the accuracy and especially the data that is used by the investors and the guarantors in considering that loan. So that gets to a point where that data is applicable to the loan decisioning. What are you doing to validate that? Certainly, the debt-to-income ratios have an impact here, especially if that applicant is on a payment plan. It's worth mentioning here that, on these open liens and judgments, the dollar amount from those can range from hundreds to tens of thousands of dollars. And if a consumer is on that payment plan, the standard guide underwriting practice, I believe, states that if there's 10 or more remaining payments remaining, then they need to be factored into the debt-to-income ratio. And certainly the same can be said of judgment and liens if the applicant is on a payment plan for those. And if they are not reflected as a line item on the credit report itself, then certainly that has an impact to the ratio. And it's not factored in most of the credit underwriting credit risk decisions that happen today, because if it doesn't show up on the credit report, it's not factored in. And as those of us who are in underwriting know, certainly that debt-to-income ratio plays a critical part in the ability to pay analysis. So while this is critical when manual underwriting is involved, it's worth restating again that the lender is ultimately responsible for validating all this information for all mortgage transactions, not just the ones that are manually underwritten. Now, also ensuring that the applicable debts are paid off prior to closing is a requirement that is standard out there, and ultimately the intent of that is to identify any existing debts which impact the applicant's ability to support the pending mortgage payment or the primary lien position when that loan when settlement occurs. Those must be addressed prior to closing. None of those requirements have changed. So again, the impact on liens and judgments here may play a role in your compliance with that requirement. And finally, it's worth mentioning that in the Fannie and Freddie announcements and their communication, that misrepresentation has always been a life of loan risk, and it's exempt from the mortgage buyback policies that Fannie and Freddie enacted back in January of 2016, where they shortened the window for repurchase risk. Fraud, misrepresentation, is a life of loan repurchase risk. There is no time limit on that. So before we move on to the consumer impacts, let's kick off another poll question.
All right, we'll take a look at a question once again about you. Is your company fully meeting investor guarantor requirements after the Bureau's NCAP-related changes? And people pretty much got the drill down now for working through this poll. All you have to do is click your answer right there on the slide itself. Is it pretty sure we're in good shape, or we might have some gaps, or I'm really not sure? So is your company fully meeting investor guarantor requirements after the Bureau's NCAP-related changes? Any insight on this one?
This is the part where we get to see whether lenders looked at the headline, the major message of the investor communication from Fannie or Freddie, or if they actually looked a little deeper to see their ability to comply with related guide requirements.
So once again, the question, is your company fully meeting investor guarantor requirements after the Bureau's NCAP-related changes? And just about everybody has weighed in on this one, so we'll take a look at where we fall. And most people are feeling like they're in pretty good shape.
Good. Good. That's a fair expectation. Again, it gets into, do you go with the headline, and then what processes do you have in place to make sure that the ability to pay test is being done properly and that you're identifying any liens or judgments prior to closing. So I think what's clear here from this poll is that the majority of our attendees feel that they have that well covered.
Thanks,
all right,
Nick.
so thank you, Mary. So at this point, let's go on to talk about what impacts to the applicants, to the consumers, as a result of the loss of this data. So while most of the media coverage on this talked about the consumers potentially having a better shot at getting a loan because of the potential credit boost to their credit score, what hasn't been discussed are some of the resulting impacts to the consumer's experience with lenders beyond getting the loan. So, for example, as a lender, if you're issuing a pre-approval commitment to a consumer, they obviously leverage that when they're shopping for a home. So the question is, how good is that pre-approval commitment if a lien or judgment is subsequently discovered? And if it does materially impact that loan approval that was conditionally issued earlier, does that create reputational risks for your company in response to that consumer's experience? Now, on the dispute side, the ability to quickly identify accurate and up-to-date information, and just as importantly, be able to clearly guide the consumer as to their corrective actions when necessary, is key to minimizing any potential adverse experience by these having to come up during some of the loan applications. And then, as we covered it earlier, regardless of the loan type, time is precious. We all know that the pressure from application to honor a closing date, there's a lot of work that happens in there, and everything involved between the application and closing needs to run smoothly in order for that date to happen. So if a lien or judgment is subsequently discovered, the lender has to confirm, obviously, one, whether it's tied, whether it's applicable to one of the parties, the borrower or co-borrower, verify the status of that record and whether it's open, and obviously potentially factor it into the HUD-1, the closing package. So the later a lender finds out about these items, the higher chance it has on jeopardizing the closing date. And again, that speaks to the applicant experience. So at this point, let's transition to some recommended next steps, or steps for confident lending in this new world. So recognize that the legal opinion of large financial institutions, including LexisNexis Risk Solutions, is that the use of non-FCRA data to identify potentially adverse information and then to order an FCRA-governed report creates compliance issues, since the non-FCRA data was used, and this is significant, in whole or in part for an eligibility decision. That's the key test. And so that is what drives the point that I made earlier, that any decision that you make, whether to kick off an FCRA process or not, is in fact an FCRA decision and should be driven off of FCRA governed data. And using non-FCRA data to make that decision puts your company at risk for being out of compliance with the Fair Credit Reporting Act. And especially using non-FCRA data anywhere close to the underwriting or the credit decision is dangerous at best from a compliance perspective. So make sure that whatever solution you're using that's being delivered to you is an FCRA-governed solution. That's a key test. Other thing that's worth pointing out, that any solution provider who states or ties the performance of their product to the performance of the credit reports before that data was dropped as a result of NCAP, actually is starting from a flawed baseline on performance. Remember that the credit bureaus dropped the lien and judgment data in response to the NCAP settlement. So that was triggered by consumer complaints of data inaccuracy. So if a solution provider to you for a third-party report is calibrating their performance to what used to be on the credit report, clearly that's not good enough. The other thing that's worth looking for is looking for something that is fast and comprehensive. And our LexisNexis Risk View Liens and Judgments report is available directly from us or through most of the top credit reporting agencies. And this report is a nationwide view, comprehensive view of any liens or judgments tied to that consumer with a degree of reliability that is in accordance with FCRA accuracy standards. So please contact us or your credit report provider to learn more about our report. So Mary, at this point, I've gone through the key parts of the webinar. Let's open it up to question and answer session, please.
That sounds great. We'll go ahead and put a poll up first, just so people can weigh in on this if they'd like to be consulted for more details and a little bit more information about LexisNexis. But yes, it is time for the Q&A. And if you would like to ask a question, several of you have already, please click on the Q&A icon that you'll find at the bottom of the screen. Type your question into the question box area that appears, or your comment, and then hit the submit button. We'll try to get to as many questions as we can in the time that we have left. So let's start with this one about that came from Jose. Jose, you said that they request supporting documents to show the judgment has been dealt with. So what other kinds of things can they use? This was something that Jose responded when you said, how does your company research potential liens and judgments in response to applications? So once again, he says we request supporting documents to show that the judgment has been dealt with.
Okay. So the process of doing that with a report where any lien or judgment record is identified, you're looking for a product that gives you sufficient information to know where the source of that record is, where the source of the record is, identifying information about it, and any of the parties that were involved with that. And so obviously the goal ultimately is to get a copy of that. Most of the county public records have the ability to access that directly. The consumer should be directed on the process for being able to do so. And for example, with the Risk View Liens and Judgments report, those who get it through a credit reporting agency or through us are given are trained on a procedure on how to guide them through the process of pulling that data, and ultimately you getting the information that you need as a lender to be able to validate, one, whether that record pertains to the borrower, but going back to Jose's question, what the current status of that report is. So for example, with LexisNexis as a provider of the Risk View Liens and Judgments report, we are not pulling that data and providing it directly to the source document to our credit report resellers or to our direct customers. But what we are doing, working with our resellers or through us directly, we're providing the information that you can provide to the applicant or to the borrower to be able to get that information, and then ultimately for you to be able to review it and check the status and its applicability.
Thank you very much, and thanks for your question, Jose. Let's look at this one here from Megan. Would the FCRA compliant report be considered a consumer reporting agency?
So for reports, for FCRA reports that are issued, yes, the expectation is that it is coming from a consumer reporting agency. And that's part of the process in terms of the Fair Credit Reporting Act, the types of companies or parties that are responsible for collecting that data, what criteria they use to pull that information, and who it's shared to. So yes, that is a criteria.
Great. How does LexisNexis source and compile the L&J data?
Okay, so LexisNexis collects data from over 3,000 counties, boroughs, and parishes in the United States. And that territory represents about 98% of the U.S. population according to the July 2015 census data, the U.S. Census data. And this data is collected from each jurisdiction at least every 90 days, with the majority of them visited on a monthly basis. And on top of the data collection, the broad area that we collect the data from, we also employ data quality and testing tools and processes that we ultimately use to assess the collection performance. So we have a collection performance management system tools to identify if there's any sources of data latency or the timing of the updates, including any of those latencies or delays that may come from our data collections tools or the actual government reporting sources themselves. So it's through the combination of this broad data collection, the data quality tools, and the processes that we use that we result in a very broad set of data, including liens and judgments, that are both current and reliable. So that's how we source that data.
And how do you accurately, what method does LexisNexis use to accurately match consumers with L&J source data?
Okay. So there are many companies who are in the business of collecting data and collecting it from a diverse set of sources. But what makes that data more actionable is the ability to link it accurately. So being able to do that, especially with liens and judgments data, for us is a combination of LexisNexis leveraging our proprietary linking algorithms. So the methodology, the technology that we use to identify whether a record, whether it's a lien or judgment or other public record, is applicable to that consumer. We also have our own cutting-edge big data technology, which is known as the High Performance Computing Cluster, or HPCC. It's widely available, but we use our own technology to be able to take this large amount of data and be able to ingest it very quickly. And then obviously, as we talked about earlier, we have these vast data resources. We effectively cover the U.S., as I mentioned earlier, over 98% of the U.S. population. So using this combination of our linking technology that uses analytics and machine learning, which is significant because it helps us minimize and avoid false positives and negative results to be able to deliver highly reliable linking outcomes. And it's probably at this time worth noting that specific to liens and judgments, prior to us rolling out our product, we actually conducted 2 studies specifically to validate the performance of our technology around liens and judgment data. In other words, was there anything atypical about liens and judgment record that would cause the performance to be different than what we consider to be a high-performing, high-reliable, and current data offerings to our customers? In the first study that we did, we measured the change in linking a record to an active consumer using that record with and without access to the consumer's Social Security number. And that test, we ran it on, I believe, 26 million records. And what's important about that, the result of that study, we found that the linking changed no more than 1/10 of 1%, or to restate it, 99.9% of the linking that we would have assigned a record to a consumer remained unchanged. So the second study that we did, we took 500 lien records, 500 judgment records, and we employed a team of our engineers who have this linking expertise to review the actual source documents and ultimately manually validate whether that linking to the consumer that our systems did was appropriate. And the results of that match quality study was determined to be over 99.7% accurate. And so we think that between the 2 of those studies, that we reinforce the conclusion that our customers can rely on the valuable content that we make to make informed and confident-based decisions, that it's relevant, it's reliable, and it's current.
Okay, well, there are a lot of data that you've handed out today in our conversation. How do you triage through it? And in fact, what do you think the most misconceived notion is that people have about this subject?
I think it's a great question. Again, I think the key messages that folks have taken from liens and judgments dropping off the credit reports was that, 1, it would have a minor or minimal impact to credit scores. And there may be truth to that, but as we talked about earlier, ultimately, as an industry, we really need a couple years to truly understand what that impact is. So the jury's still out on that. But what I think is clear, and I think we saw some of that from the poll questions, the survey results, was that a lot of lenders looked at the media and the actual lender guidance from the investors, from Fannie and Freddie, and said that ultimately no other action needs to be done, that even though it's dropping off the credit reports, or at the time that they issued the guidance, the expectation was some of that data would still be there, and since that time, the bureaus have dropped all of that data. And so if you actually look into the investor guidance a little bit and look at what the impacts are to you in terms of your experience with a consumer and truly your ability to meet some of those investor requirements where the liens and judgments may play a material effect, I don't think has been covered as widely covered. And I think it was worth bringing up here, and I think those are key messages that many folks have not really appreciated as a result of the NCAP settlement.
Kim has a question for you. How does LexisNexis handle consumer disputes on the data reported to the lender?
So I believe I mentioned earlier that depending upon whether you're obtaining the LexisNexis Risk View Liens and Judgments report directly from us as a direct customer or through one of the many credit reporting agencies, there's a process that we go through in a dispute process in terms of being able to do some research. So for example, if you're a direct customer, there's a phone number that we provide. There's a process and training that we go through in terms of identifying how we would work through any sort of consumer disputes like that. If you're getting it through a credit reporting agency, we've coordinated with them on the same thing. They have a number, they have a process to coordinate with us, and ultimately we go through and being able to look through that information and provide the update back to either our direct customer or to the credit reporting agency who is well familiar with their dispute process and how they respond back to the end lender or the customer there.
Thank you, and thanks for your question, Kim. Lots of information today. What do you think we should take away from hearing this presentation?
Well, first off, those of you who are on this webinar today, we appreciate the fact that you're doing more research, looking to see where the market is nowadays, basically a little more than a year after, and being able to see what sort of impacts, if any, are out there. I think we've covered that information today here, and those of you who are on the call, we really do appreciate that you take the time to look at this and consider the applicability of that information to you and your process and your company's reputation.
Thank you very much for your presentation, Nick, and thanks to our audience as well for joining us. We're really pleased that you were able to attend today's webinar and hope that you found it valuable. Also, thank you for sending in your questions. If we didn't get to your question, we will follow up with an answer after today's webcast. Today's presentation and webinar recording will be distributed to all registrants shortly after today's event. Again, thank you and enjoy the rest of your day.